Hey everyone, welcome to NIJC's Policy Corner, and we are really sorry for the delay. We had some technical difficulties on our end, but I want to welcome all of you here today. My name is Heidi Altman. I'm the Policy Director at the National Immigrant Justice Center, and I'm going to introduce our lineup today and provide a little bit of an overview of what we're gathered to talk about. First and foremost, as we always do, I just want to thank everyone who is on the call and who's dialed in for taking an hour of your time to talk about these important issues and to support NIJC and the work in whatever way that you do. We are grateful. And I also want to thank Nubia Fimbres and our policy team who is behind the scenes making all of this go today. So Nubia, I think we can go ahead and click into the slides. I just want to begin for those of you who maybe are new to our policy corner or are new to NIJC by doing a little bit of an overview of who we are. So the National Immigrant Justice Center is a Chicago headquartered organization. We have offices in Illinois, in Indiana, in California, and in Washington, D.C. And we integrate legal services, federal impact litigation, communications work, and policy work. And by policy work, we mean advocacy at the federal level, on Capitol Hill, legislative work, regulatory work, and executive action and advocacy with the federal agencies and the White House. Our policy team does our policy corner. We come together quarterly to share out some of the work that we're doing in our federal advocacy. And our work on our policy team at NIJC centers around the pursuit of transformative change. So we're looking to impact the systems that our attorneys and our clients and their families and communities struggle in every day that often discriminates against and denies fundamental rights to individuals in those systems. We're looking for transformative change that moves those policies and systems to an embrace of humanity, collective wellness, and human rights. Today, we are going to be talking about family separation. And thank you, Maria. This is our agenda for today. I want to explain the impetus for this being our topic. As many of you know, one of the commitments that President Biden made on the campaign trail early in his administration was that he would try to make right, to the extent possible, some of the wrongs of the families who were separated during the zero tolerance policy during the Trump administration. Early on in the administration, there was a task force set up that is still operational today that aims to reunify as many of the families as possible who were separated during the zero tolerance policy. And we'll talk in a little bit about what that was and what it looked like. As part of the work of that task force, a little while ago, the Biden administration put out a request for comments through the Federal Register, basically asking people to provide input and analysis as to how the administration could prevent the separation of families. Given the work that we do, the work that our legal teams see, cases that are active and on which we're advocating right now, this request for comments really raised our eyebrows because tragically the Biden administration has continued many policies and programs that systemically separate families. And so we used the Federal Register publication as an opportunity to provide analysis of what those programs are, how they continue to systemically separate families, and to make recommendations for the administration to finally rethink family unity in the context of immigration enforcement. Because for everyone who I think works in the immigration system in any way or those impacted by it know, tragically, the separation of families has long been central to the enforcement of immigration laws in the United States. So we're really lucky to have with us a wonderful team of providers today, and my cat, I apologize, who are going to be speaking to three sort of categories of policies that are still central and embraced by the Biden administration that separate families. The first is the prosecution of migration-related offenses. The second is anti-asylum policies at the border. That includes the migrant protection protocols or return to Mexico program and the mass expulsions under Title 42. And then lastly, we'll speak about interior enforcement and detention. So I'm going to ask that each of our presenters introduce the next, which means that I am lucky enough to be introducing Jesse Franzblau, who is a senior policy analyst on our policy team and has done a tremendous amount of research into and advocacy around the issue of migration-related prosecutions. Jesse, I will toss it to you to kick us off.
Thanks so much, Heidi. Thanks everyone so much for being here. So I'm going to speak a little bit about migration-related prosecutions and the way in which these prosecutions continue to fuel family separations, as well as other systemic abuses as they're carried out. Just a little bit of background, because we've discussed this before, and we'll share more of our background material and reports on this, but the laws used to prosecute people for entering and re-entering the country, these are sections 1325 and 1326 of 8 U.S. Code that are part of the INA. These laws were passed in the late 1920s during the height of the eugenics movement, and the laws were explicitly passed with racist intent to further white supremacist ideology. And these prosecutions continue to have a starkly discriminatory impact, and they were really at the root of the family separation policy during the Trump administration, when the former administration sought to prosecute every single individual, regardless of if they were coming with their family, everyone who entered outside of a port of entry for prosecution, for criminal prosecution for unauthorized entry. But what we found in our research, and NIJC carried out surveys with individuals who've gone through prosecutions, as well as extensive interviews with federal defenders and rights groups regarding the use of such prosecutions and observed prosecutions carried out. And in the next slide, we talk a bit about the research that found that the U.S. government's prosecutions for unauthorized entry and reentry consistently violate asylum law, violate due process protections, lead to dehumanizing and racist treatment, as well as cause permanent separation of family members. And so in the next slide, we can go to the next slide, where we discuss the current context today under the Biden administration. So the Biden administration rescinded the zero tolerance directive, which is of course important, but the administration continues to rely on unauthorized reentry prosecutions, and is again referring people for unauthorized entry prosecutions. And last summer, CBP announced they were launching a repeat offender initiative where single adults would be prosecuted if they had been previously apprehended. And this was a way that the administration is basically targeting people who have been under the Title 42 expulsion program who are trying to return. And my colleague Azadeh will speak more about the Title 42 program. So in the next slide shows some of the graphs and some of the findings about what is currently taking place under the Biden administration, where these prosecutions are continuing. On the next slide, we have a couple of stories that we raised in the comment that we submitted to the Family Reunification Task Force that illustrate the really tragic harm that these prosecutions lead to. And in one case, and this story was shared with us by the federal defenders in San Diego, who represented an individual, an asylum-seeking father who in September of last year was prosecuted for unauthorized reentry as he was trying to come to the U.S., return to the U.S. to be with his family. But because he was sent to prison because of the unauthorized reentry prosecution, his immigration attorney wasn't able to be in touch with them, and DHS deported him, removed him to Tijuana, and tragically he was killed there and left behind his daughter, his newborn daughter and partner. And another story that we wrote about is an individual named Luis, who was brought to the US from Mexico as a baby and was deported in 2003 and tried to return several times to be with his family, and was prosecuted for unauthorized reentry in 2017 and is serving out a 6-year sentence still because of this. So those are just a couple of the stories that illustrate the broader systemic harm that these prosecutions continue to have. On the next slide, we talk about a bit of the recommendations that NIJC has worked on, with a lot of other groups and criminal justice organizations have worked on recommendations, first calling for these laws behind prosecutions to be repealed. So for Congress to repeal the laws so those prosecutions will not continue. And short of repeal, the asks for the administration, for the executive branch, are to suspend referrals for prosecutions, and then short of suspension, the recommendations are to terminate all programs that target asylum seekers, and also exercise prosecutorial discretion, and as well as vacate prior unauthorized entry and reentry convictions. So the next issue I'm going to discuss briefly is our other policies and programs that lead to family separations. And so I'll discuss a bit the Miss L case. So in the case of Miss L versus ICE, this was the legal challenge that essentially ended or helped end the zero tolerance program. But what happened in this case was that Miss L, the court allowed for separations to occur in certain circumstances, and DHS basically exploited the loophole to continue to separate thousands of families who the government determined fell outside of the Miss L class. And so DHS, in doing this, frequently used unsubstantiated and erroneous allegations of terrorist activity or criminal activity or gang affiliation to separate asylum seekers from their children. And this all took place after the zero tolerance program ended, and the risk is that this, of course, continues today. And in the next slide, we discuss a bit how since June 2018, NIJC has represented more than 100 separated children and parents, separated because DHS alleged that the mother was gang affiliated and excluded from the Miss L class. In nearly all of these cases, however, the women were victims of gang violence, and NIJC was able to disprove the allegations of gang membership. And we discussed a couple of these stories in the comment that we submitted to the Family Reunification Task Force. And these are both mothers from El Salvador who were criminalized as a result of foreign data information sharing programs, which resulted in CBP making a determination to separate the mothers from their children. And it took intervention from attorneys to help disprove the allegations against the mothers and help reunify them with their children. And so in the next slide, we discuss the recommendations that we included in the comment to the Family Reunification Task Force. And one of the main recommendations is to ensure that people who are separated and who fall outside of the Miss L class are included in the reunification efforts. There's no reason that these individuals, these family members, should continue to be excluded from any type of reunification efforts. Another recommendation is to end the reliance on gang affiliation in CBP and case enforcement practices, and terminate foreign intelligence sharing agreements that lead to separations of families, as well as instruct DHS to provide justifications, including copies of any evidence or other documentation of alleged criminal accusations, and then conduct a thorough examination of the current practices relating to gang-based enforcement programs for their potential rights violations. So with that, I look forward to hearing questions and discussing after. And now I'll pass it to my colleague Azadeh, who will discuss the reinstatement of MPP, as well as the Title 42 program. Thanks, Azadeh.
Thank you, Jesse. Yeah, so switching over to Remain in Mexico, a policy that the Biden administration, including the First Lady, condemned a long time ago and tried to terminate early on during the administration. So a reminder of how we got here, because at this point, MPP actually turned 3 years old last month. It was first initiated on January 25th, 2019, and it was really troubling come last month to realize that this policy is still here and that its wind down is hard to anticipate at this point. So it was the brainchild of Trump administration officials, including Stephen Miller, who used a 1996 statute to effectively shut down asylum at the US border for non-Mexicans. And despite high officials, including the president, condemning this policy, and the DHS Secretary Mayorkas also condemning it, trying to terminate it, litigation ensued. And a Texas judge basically stayed the termination of the MPP policy, which had actually contributed to the return of about 13,000 people up until then, and gave the Biden administration two options. Either you have to restate this policy in good faith, or end it by bringing to bear the full record of atrocities that you claim are undergirding this termination. Unfortunately, the radio silence from the Biden administration for over 2 months. Over those 2 months, basically, the assumption was that the policy was here to stay, and a lot of credible rumors came out from reporters who were speaking with high officials, basically stating that they welcomed the policy, that they thought that MPP or MPP 2.0 or whatever light version of MPP they have in mind will be sound border policy because it will deter people from coming to the US. Clearly the same kind of rhetoric that led to the implementation of MPP in the first place. And then after 2 months, the Biden administration terminated and then lost in court and had to reinstate the policy. So the policy has been back in effect since December and has been expanded to impact even more people in the Western Hemisphere, including Haitians, including people in the Caribbean. So there's a lot of fear that this new iteration of MPP is going to be far from a light version, but actually impact a lot more people. So how does this even connect with family separation? You may be asking yourself. Frankly, MPP has been a really powerful tool for family separation. It's been kind of a backdoor vehicle for that. So families typically would approach the border, and at the border, because of these obligations to come to the US in order to attend these hearings, they were very easy prey for different criminal entities who then would inflict violence, kidnap them, and extort them. And many families, as many as 700 or more, actually ended up sending their children alone, or ended up having, parent ended up kidnapped and child got released, and out of sheer desperation, basically the child entered the United States as unaccompanied instead of with their parent. So that's the kind of vehicle that oftentimes gets ignored with respect to the zero tolerance policy, family separations. If we actually zoom out and look at other border policies, Remain in Mexico is very much a driver for family separations as well. And that should be one of the main reasons why this administration should end it once again. On to the next slide, I want to talk about a companion policy that is called Title 42 expulsions. Also an invention from Stephen Miller, who had been brainstorming a long time how to weaponize public health in order to halt migration to the United States. And basically, all of that is premised under the idea that migration brings contagion, that migrants are to blame as vectors for disease, something that's very steeped in eugenics and white nationalist ideology. So with those purportedly fringe theories, we actually ended up getting, in March of 2020, a whole new track for deportations called Title 42 expulsions. And basically, that uses a statute from the 1940s that had to do with quarantine and weaponizes that as a mass deportation tool. And as you can see in the slide, about 1.5 million people have been expelled. Some of them have been expelled multiple times, so it sort of inflates the numbers too there. And a lot of these expulsions, the vast majority of them actually occurred under the Biden administration. So it's been a tool for the Biden administration to try to minimize the number of entries into the United States, even though it has led to the same kinds of harms as we saw with Remain in Mexico or MPP. So those kinds of harms include what you're seeing in the slide, this 10-year-old Wilton who was found by a Border Patrol agent. I think it was back in April, and Border Patrol agent actually started recording and recorded himself interviewing the kid, and the kid was basically like, I came here by myself, right? And my mom is not with me. And upon digging a little bit further, it became clear that he and his mother were previously expelled under Title 42 by Border Patrol, and then immediately captured by people who kidnapped them, right, and kept them for ransom, asking for $10,000. And then the mother reached out to some relatives in Florida, and those relatives could only afford to give out $5,000. And their kidnappers basically decided that means only half of you get released. And they released the little boy alone, who was then found wandering in South Texas. So the same kinds of things that basically happened under MPP are happening now with Title 42. And the combination of those two is particularly concerning because, we know this administration has said many times that they care about family separation, but they seem to ignore the impact of these border policies when it comes to driving separation of families, either out of sheer desperation or simply because of the crisis that they have created for them at the border. And on the next slide, I actually want to draw attention to the fact that Wilton's story that we just saw is remarkably similar to our client Lina. Lina is a pseudonym that we're using here to protect confidentiality. But Lina is actually currently separated from her mom after they were both subjected to MPP and Title 42, and they were actually separated under the Biden administration. So as you can see in this slide, Lina is a 10-year-old girl from Central America, and she was originally enrolled with her mom in MPP or Remain in Mexico, and all three of them were kidnapped at the US border. And as they got released from their kidnappers, they crossed into the US border. They were exhausted. They were completely at their wits' end. And her mom and her sibling fell behind because of this exhaustion. And Lina, who suffers from cognitive disability, basically proceeded alone. She didn't realize that they had fallen behind. and she went ahead and entered the United States, was apprehended alone in the United States. All three of them by then had actually made it to US soil. So Lina is processed as an unaccompanied minor, as if she didn't attempt to enter with her mom. And when her mom and her sibling make it to Border Patrol, they explain the situation. They are desperately waiting for Lina to show up because they have no idea where she is. Instead of reunifying this family, the Border Protection basically proceeds to expel them. So now this family has been separated for over 9 months because mom and sibling are back in Mexico, and this unaccompanied child is sitting in the custody of the Office of Refugee Resettlement, anxiously waiting and just simply not understanding why her mom can't be with her. So again, those are the kinds of policies that we're talking about. This is why Title 42 and MPP must be ended, and why our recommendations with respect to family separation would be flawed if they didn't refer back to these policies as drivers of the separation of families. And with that, I'm actually going to transition it over to Lina to talk through how detention and deportation themselves are also vehicles for family separation.
Thanks, Azadeh, for all of that. Great to have all of you here. I'm Lina Gupta, Associate Director of Policy here at NIJC. And just as Azadeh mentioned just now, we know that detention and deportation in the interior of the US, so not just at the border, but in ISIS practices around the country, is another way in which DHS is separating families here in this country. And so a whole host of aggressive detention practices that lead to this family separation, including the use of mandatory detention, overbroad definitions of criminal convictions in the Immigration and Nationality Act that results in deportation and detention of so many folks who've had even minimal contact with the criminal legal system. We know that cooperation between local police and ICE leads to this kind of family separation in communities where there is that kind of entanglement. And we know that folks with lawful permanent resident status who've lived here in this country for many years, who are supporting their families, are often subjected to deportation and detention and separated from their livelihoods and their families in the same way that we've already described in these other arenas. And the backlogged immigration court system and slow process in actually moving through immigration removal proceedings means that there are folks who are sitting in detention for many years, which means extended time away from family. Deportation numbers, we've seen under the Obama administration, there were 400,000 deportations. Under Trump, quotas for immigration judges led to more detention, more deportation, and more separation from family. So here in front of you, just to share with you the story of one of my former clients, Joseph De Paz Salas, who's a 21-year-old young man. Today he's 21. At the age of 17, Joseph, unfortunately, he was a DACA recipient, an honorable student. He had never had contact with the criminal system, found himself babysitting his baby sister who choked to death and passed away. And this trauma that was imposed on him and his family, and the guilt that he felt from this, pushed him to hanging out with the wrong crowd at school, pushed him away from his family, led to his first contact with the criminal legal system at the age of 18 because of drinking and marijuana use that he'd started to engage in. And the sole conviction that he picked up as a result of this very traumatic time in his life led to a felony conviction that the criminal judge said only needed weekends in jail for 2 months and a lot of counseling and rehabilitation. But this triggered, of course, the ICE detention and deportation machine. And that's when I met Joseph, was when he'd been transferred to ICE custody to Yuba County Jail in California, where he then sat for 1.5 years, including a prolonged and extended time in solitary confinement. Again, because of this one conviction, despite the fact that the criminal judge in his case had said that the time he needed inside a facility should be very short. In that time, because of where he was housed, he was unable to see his family, could rarely speak with them, both because of distance, phone access issues, and their own fears about being picked up in the immigration system. He suffered 2 suicide attempts, and it was only after, several attempts at litigation in federal court that we were able to secure his release and ultimately win his case. But by that point, that separation from his family after this traumatic event that he'd witnessed with his sister resulted in what is still ongoing PTSD, anxiety, and depression that plagues him as he tries to rebuild his life. And the photo that you'll see here before we turn to the next slide are photos of pieces of jewelry that he made using plastic given to him by officers during his time in solitary confinement, jewelry for me and his family members as his only way to kind of keep busy and distracted amidst the trauma of detention and separation from his parents. So if we can go to the next slide, the trauma that Joseph faced is, similar to trauma imposed upon millions of children in the United States who bear the brunt of these oppressive detention and deportation policies. So you can see here from 2011 to 2013, it's estimated that 500,000 children in this country faced some impact or result of immigration apprehension, detention, and deportation of at least one of their parents. And there's a growing body of medical research that really documents in detail what that effect and impact is on childhood development. Parental deportation is considered now by psychologists to be an adverse childhood event. That means that this event, like abuse, domestic violence, parental mental health illness, and neglect, actually affects the neurobiology of a child's brain at an age when brain development is particularly critical to future health. There have also been studies on how deportation causes what is called toxic stress accumulation, which increases the risk of depression, anxiety, isolation, and other documented behavioral problems in children who've been separated because their parents have been deported or because they themselves, like Joseph, have found themselves in detention or subject to deportation. If we can go on to the next slide. In light of these very painful harms and well-documented harms for folks who've been separated from their family, especially for children, NIJC recently released last year a paper called A Chance to Come Home, a roadmap to bring home the unjustly deported. It offers the Biden administration a proposal for how they can help bring home folks who have already been victim to the deportation and detention machine so that they can reunite with their families. On our next slide in a moment, you'll see a link to that paper, but this here, if it plays for us, I don't know if we have any technical difficulties, is a video of one of the individuals featured in our paper, Howard Bailey, a US veteran who was deported over a decade ago for a sole marijuana conviction, dragged from his front lawn, hadn't seen his children or his ex-partner in over a decade, and using some of the processes proposed in our paper, Howard was able to finally return just last year. And this is a video of his return. If that doesn't work, or maybe let's see if it works for us. There we go. That's his whole family. They're at the airport awaiting his arrival, as well as some news reporters. You can see him there walking off the plane from Jamaica, where he'd been essentially exiled for 10 years. Howard has spoken eloquently in several public forums on the pain of losing his children especially, and how his successful, loved children derailed after his deportation and after losing the economic support he provided his family. And so on our next slide, you'll see there a link to that Chance to Come Home roadmap that tells the story not only of Howard, but 10 others like him who are emblematic of the thousands of folks who've been separated from their families. And we would love if you would be willing to sign our petition calling on the Biden administration to set up a central process as we propose to help reunite families the way that they say that they're committed to. If you click on that link, you'll be able to fill in your name, read a short summary of our proposal. Our hope is to gather more and more signatures on this as we continue to advocate to bring others like Howard home. And so with that, I will turn it back over to Heidi, and we'll be happy to drop that petition into the chat as well so folks can click on it directly. And actually, I can just finish up here. There's other opportunities to get involved. You can check out our website. Of course, as always, we say on our policy corners to really think about communicating with your members of Congress. It helps for them to hear from you all, not just from us who are advocating every day on the Hill. And then for those of you, who are working at law firms and take on pro bono cases, we have at least 60 clients who are currently in need of pro bono counsel, and we're always hearing from more and more folks who need that support. So with that, I'll turn it back over to Heidi, who will field, I think, questions and answers for us. Thanks, Heidi.
Thank you so much, Nina, Jesse, and Azadeh, and Nubia behind the scenes. So I'm going to invite everyone to come back on camera, and I want to invite everyone listening to please feel free to drop your own comments or insights or questions into the chat, and we're gonna field a few of the questions that have already been dropped into the chat throughout. So I'm going to start off with a question for Jesse. So there was a question asked by Allison, thank you, Allison, about a landmark decision that came out of a federal district court on the invalidity of the section of the federal immigration law that allows for the prosecution of unauthorized re-entry because of its racist origins. And so, Jesse, I was hoping you could just speak for a moment about that decision, its basis, and where that litigation and others like it stand.
Yeah, absolutely. So this was a really interesting and pretty groundbreaking decision that came out of a Nevada lower court last summer, the end of the summer, where the court found that the statute, section 1326, was not only enacted with a racist history and racist intent, but also has a discriminatory impact that continues, and in finding and in that finding dismissed a charge against an individual who had been charged with unauthorized reentry. And it's a really enormous decision. It's the first decision that the court has found that these prosecutions, because they have such a disproportionate and discriminatory impact on Latinx populations, Latinx communities, that they violate equal protections, essentially, and violate constitutional rights of individuals being referred to these prosecutions. Unfortunately, the government is appealing the decision, and their reply is definitely incredibly disappointing and very opposite of what this administration says in terms of their rhetoric on racial justice. If you look at the reply that the government has given in this case, continuing to challenge this decision, it's quite the opposite. It basically is upholding these statutes and essentially saying that even if they have a disproportionate impact and they're discriminatory, the government can enact policies and programs that have a deterrence effect because they have the authority to do so for immigration enforcement purposes. We'll be sharing more about that soon in the upcoming weeks. But yeah, it's a really interesting decision to watch.
Thanks, Jesse. Asade, I'm gonna ask a question that hasn't come up in the chat yet, but I think was really prompted by your comments and is sort of in the news, ripped from the headlines, as they say. A few days ago, there was a story, I believe it was in Axios, reporting that the administration is considering requiring COVID vaccinations for asylum seekers who might be considered for entry either as an exemption to the Title 42 expulsion policy or through MPP. And you did some writing on our website about concerns that that policy would raise, and I was hoping you could talk a little bit about that with us, and I'll drop the commentary in the chat for all those listening.
Yeah, sure. And yeah, that commentary, which is from Jesse and I, has to do with the basically raising some of the red flags that come up with respect to this vaccination, potential vaccination exemption. So at bottom, right, we're in a pandemic, and it may sound like common sense to require people to enter with vaccination, with proof of vaccination, but that is actually fundamentally at odds with the domestic and international asylum obligations, and it imposes an incredible hurdle that people may not be able to overcome with respect to coming to the US. So there are very few vaccines that the US, the Food and Drug Administration has approved as acceptable. And many of those vaccines, for example, are not available broadly in Mexico or in Latin America. And those vaccines basically would not be acceptable anyway, even if someone had the privilege of having been fully vaccinated. But in addition, it really doubles down on the vaccine inequity that we already see in the world. Some call it vaccine apartheid, with 7% of the continent of Africa having had access to vaccinations, less than 1% in Haiti. So it's really troubling to think of that, of that requirement doubling down on existing inequities that, victimize people on the basis of their economic or racial status. So, and the last thing I'll drop is, again, it brings up this idea that migration or the right to seek asylum could be a source of contagion, which is a really, really problematic idea, and something that landed Haitians who were seeking asylum in the United States in Guantanamo Bay in the 1980s and 90s. So it's really troubling to think of that specter as coming up once again.
Thanks so much. And Asade, if you don't mind, if we stay with you for a moment, there is an interesting conversation happening in the chat about sort of why people who are fleeing certain countries may be sent back to their countries to expulsions while others are being let in. And I think that that really connects to the point you made about how family separation is often caused in a more complicated way by the choices that families have to make because of the sort of complex web of policies that are now overlapped at the border. And so I was hoping you could just elaborate on that a little bit. You dropped in a chart that I think is kind of a perfect illustration of this, but the ways in which a family fleeing violence, approaching the border might be confronted by a sort of chaotic and random application of various sets of rules.
So first off, I just want to validate the fact that none of this makes sense, just from a basic point of view. Like, if it doesn't make sense to you now, you should hang on to that, to that surprise and that, those questions, because ultimately, people should not be treated differently on the basis of their national origin. That's a very fundamental premise of how, the immigration laws in this country were supposedly modified in the 1960s to get rid of these inequities. But at the same time, some countries have said that they will not take back expulsions. And because of that, some individuals are just not being expelled to those countries and are instead being placed in Remain in Mexico. So there's a little bit of triaging basically that the administration does, and between the these unwritten rules and negotiations with foreign nations and the mere whim or discretion of the agent that you have in front of you, there's a host of possibilities, right, that could arise for people based on their national origin. And the last footnote I'll add is there was actually an article from CNN yesterday that stated that the administration was getting around countries rejecting expelled individuals because they were expelling Venezuelans to Colombia. So that kind of what international law would call potentially chain refoulement is really troubling, and it shows again the administration's intent to push back, to basically make it as hard as possible for people to come to the United States and seek protection.
Thank you so much, Azadeh. I'm going to take a moment to just scan the last question that has just come through on the chat here. So there's a question about sort of the numbers at the border and whether we have any insights into the long-term policy of the Biden administration toward Title 42. I will note that obviously there's been mixed reporting on this. For those of you who are interested in this sort of, I think, deeper questions of what political and other factors have resulted in this administration really backtracking on many of their promises with regard to asylum protections. There is a profile in the New Yorker of a White House staffer who left after having been involved in the sort of end of MPP and only to be faced with the prospect of being involved in restarting it. There's a lot of insights into that article, and I think what we know about Title 42 is that in litigation, where there were actually just oral arguments on the litigation that the ACLU has brought on Title 42, the government has just continued and consistently relied on a public health justification for these expulsions, even as sort of evidence mounts and mounts and mounts that the consensus of the public health community is very clear that there is no public health justification for Title 42 expulsions. So I'll open that last question up to the panel before we close, if anyone wants to add any last thoughts. Okay, I'm gonna then actually close with just a note of gratitude. I know that we always have such a really fantastic mix of colleagues and friends and supporters who join in for these calls, and I know that many of you are involved in doing work in one way or the other that is helping to try to reunify families who have been separated or to prevent future separations. We thank you for that work. We thank you, those of you who actually went ahead and submitted comments as we did on the Federal Register notice. And we thank you for taking your time to be here today. We hope you will share some of what you learned with your friends, with your family, with your colleagues. We hope you'll be in touch with comments and that we will see you at the next Policy Corner. Thanks so much for being with us today.